Hi guys, and welcome to this lecture on party walls. I've put loads of information onto the system for you to have a look at. Party walls is an area of building surveying that we often get involved in, even if we don't act as a party wall surveyor. You need to know about it if you're doing adaptations, alterations, all sorts of other things. So please be aware of it. So the Party Wall Act recognises two types of party walls, particularly. A party wall, if it stands alone astride of a boundary belonging to two or more different owners. Such a wall is part of one building or separates two or more buildings, as you can see from that diagram. Then we have got a party fence wall. So this is this diagram here, and it's where it's not part of a building, but it stands astride a boundary line between two different owners. So it's a slightly different, a garden wall, for want of a better word. You have also got a situation on this diagram where the original property has extended and therefore has created a party wall at the lower part of the property, because this side, this bit of the wall is now enclosed, whereas the upper part of the wall, where the boundary line runs down the face of the wall and it's open to fresh air, that is not a party wall. And then the final one is a party structure, and this occurs in flats and predominantly is the floors and ceilings between two flats. So, what's it all about? Came into force in July 1997. It only applies to England and Wales, and it's based on previous London Building Acts. Now, this has been around in London. This has been around in London for a long time, and it was just extended to the rest of England and Wales to give both parties a sensible dispute resolution element for any works on or to or near a party wall. Sorry. So, in a literal sense, it's the dividing wall, i.e. the wall between semi-detached people. It can be jointly owned, or it is owned jointly, and each owner is liable for the side of the building that they have. So it's really important to identify where the legal boundary goes through the wall. So the Act enables owners to carry out work subject to the conditions of a legal process. It enables adjoining owners to challenge the work. It protects both owners and it gives a framework. One of the things to remember about this is, unlike planning, where people can appeal against it, this is a legal process. The surveyor is responsible to the Act, not the building owner. So you can't adjust what happens. It is a process which you must follow. So predominantly, it deals with any work being done of a significant nature to a shared property wall. It deals with any work on a boundary wall, any new building work between two properties on the boundary line, or any work excavation work, new build in close proximity to the boundary line. Now, I'll go through each of these in detail, okay? But basically, first thing you need to do is establish if it is a party wall under the Act, and then you need to follow the procedure. So if you're dealing with an existing boundary wall, an existing party wall between two buildings, if you want to insert a beam or a DPC, or even at roof level, you want to insert a lead flashing, if you want to demolish and rebuild part of the wall, or if you want to underpin any part of the wall, then it comes under the Act. So it's anything that might cause structural damage or damage the adjoining owner's property by you working on that wall. It doesn't cover things like drilling a hole to put a picture up, chasing into a wall to rewire, replastering, or anything without structural effect. So just be aware of what it does cover. It's if you're actually cutting into the wall, putting something into the wall, that kind of thing is important. Now, there's a very strict process. The person who wants to do the work is the building owner, and they must inform the adjoining owner, that's the person who owns or leases the adjoining property, in writing. If they fail to go through this process, the adjoining owner can go to court and get an injunction to stop all the work. And whatever they're doing, they're not allowed to cause unnecessary inconvenience. So there might be some inconvenience, because obviously if you're doing work to a wall, it's going to be noisy. But what you can't do is start work at 4 in the morning and carry on till 11 o'clock at night. It's about reasonableness, I suppose. So, as I said, the building owner is the person who is having the work done to the wall. Now, adjoining owners, they can be different. So, anybody who's got a legal interest in the building. So, even if you've just got one wall and one adjoining property, there might be more than one adjoining owner. For instance, if the property next door is let, then and it's let on a lease which is more than a year in length, then the tenant and the owner of the building are both adjoining owners, and they both need to be notified, and they both need to agree to all the work, and they can both have surveyors and everything. So you keep them as two completely separate things. So, each owner, unless they agree otherwise, has their own appointed surveyor. And the two surveyors, when they accept their appointments, they need to agree on a third surveyor should they fall out during the process. So, like I say, we've got the 3 different types of things. So the party structure notice is the one which is done on the party wall. That's the wall between 2 parts of the building. A line of junction notice is where you're doing the garden wall, and a 3 or 6 metre notice is where you are excavating. So if you are working on an existing party wall, what are your rights and what are your duties? So, as I've said, you can work on the wall, you can undertake work, but if you're going to put in a beam or a DPC or something that might cause damage, you've got to let the adjoining owner know. So you have to serve them with a notice. Now, both the government and the RICS guidance notes give you a standard letter to send to the adjoining owner. Use it. Don't make up your own, because you've only got to make one typo and the whole thing's invalid. So use it. And you need to give notice appropriately. So make sure you give it in good time. I've talked about who an adjoining owner is, and if they're leasehold or freehold. You issue the notice, and for a work on an existing party wall, you have to give at least 2 months notice. So you can't start work for 2 months after you've got agreement from the adjoining owner. And if you don't get that, there's a whole process that I'm going to go through. You can start earlier if the adjoining owner agrees. So if you're putting a new building on the boundary line or building a boundary wall, then what do you have then? Well, you do exactly the same, but you have 1 month in which to serve the notice. So the whole process is the same for each one. Now, if you're excavating, again, it's 1 month. And you have to look at it in terms of how close to the building you're excavating and how deep you are going. So in this instance, yes, if you are, say, underpinning, or you are creating any excavation, so it might be laying drains, for instance, you have to take a measurement of 3 meters from the front face of the adjoining owner's building to the edge of what will be your excavation. Not the thickness of the wall, the excavation. You also have to determine how deep you're going to go, and if that depth is lower than the adjoining excavation, than the adjoining foundation, you must serve a party wall notice. Okay, now if for some reason you don't know how deep the adjoining owner's foundation is, so if it's different to your own, you are allowed under the Act to dig a trial hole to find out, so that you can verify what needs to be done. The next one is if you are over 3 meters away but within 6 meters. Now this is far more complicated. So here you take the 6 meters is measured from the center of the foundation at the bottom of the foundation, and you draw a 45-degree line. If the distance from the center of the foundation to the edge of your excavation is 6 meters, and that 45-degree line cuts through the foundation, your foundation, you must serve a notice under the 6-meter rule. So what happens next? You have to wait 14 days to get a response. If you don't get a response, or you cannot agree with the adjoining owners on the work to be done with the party wall, then you need to move it to the next step. If you hear nothing, then you are entitled to appoint a surveyor on behalf of the adjoining owner, but under no circumstances can that surveyor be the same as your own surveyor. So be really careful about that. What does the surveyor do? The whole point of the surveyor, or the surveyors, is that they agree about how the work's going to be carried out to ensure that there isn't damage to each property. And then they look at, what's the word I'm looking for? They carry out a condition survey before the work starts, so they know the condition of the adjoining property, just in case anything goes wrong during the works. Now, the unfortunate thing is that all of the fees for the works that the surveyors do, both the building owners and the adjoining owners, this is paid by the building owner. So the adjoining owner has no liability for fees. Generally speaking, there are occasions when it changes. Now, each surveyor, if they agree, they will issue a surveyor's award. It's final, it's binding. However, if the building owner or adjoining owner can prove that one or other of the surveyors was negligent and acted outside of the act, then they can appeal within 14 days. The building owner pays for the work. The building owner pays both sets of fees. Sometimes the third surveyor's fees can be split. And if you end up in a judgment and the judge thinks that the adjoining owner's been difficult, then they will award fees against the adjoining owner. So I've already talked about this, but you must do a pre-start condition schedule. Buildings inspected by both surveyors. They do a schedule of condition. They get a load of photographs. They highlight any defects, and if there is any damage, then the building owner will be liable to pay the costs for remediation. The party wall award formalises the agreement of the two surveyors. It gives key dates, it gives the description of the work, it will include drawings, any agreement clauses. It must be signed by both surveyors or the third surveyor if agreement can't be reached. During the works, the surveyors may make inspections. They have authority to stop the work if it is being done outside of the agreement of the Party Wall Act. They can have access to neighbouring land, and if during the contract period there needs to be adjustments, they can deal with that as well. Once the job's complete, they will do another joint inspection with the initial schedule of condition to ensure that no damage has been done, and if damage has been done, they will agree the works which need to be done to rectify it. Oh, we're coming to the end. So, what are the rights of the adjoining owners? They have a right to appoint a surveyor to resolve any dispute, and again, those costs are picked up by the building owner. They are allowed to require reasonably necessary measures to be taken to protect their property from foreseeable damage. So that might be hoardings, tarpaulings, things like that. They shouldn't be put to unnecessary inconvenience. So there might be things like if you're causing a lot of dust and dirt and everything else, you may need to pay to have their windows cleaned on a regular basis, things like that. Be compensated for any loss or damages caused by the works. And if they're not sure about your ability to be financially sound in terms of carrying out the works and doing any remedial works, then they can ask for a bond to be taken out in case you default on completing the works. So that's something that they can do. Okay, any questions? I have kind of rushed through that a bit. I will give you the two guidance notes, the RICS one and the government one, from which most of this information has been taken. Have a really good look through it, work your way through the process and understand it, and I'll answer any questions next week. So thank you.